Welcome to the People's Law School. My name is Mark Whitlow. I'm a partner in the law firm of Whitlow, Roberts, Houston, and Straub here in Paducah. With me is Doug Sullenger, or Wes Sullenger, excuse me. He's with Crone and Mason at the executive end. Wes, welcome. Good to have you with us.
Good to be here, Mark.
Wes and I both practice employment law, and one thing that always comes up when we first get a call from a client to be is that they have encouraged or had a problem at the workplace. They think they've been treated unfairly and they want help. So what are some questions that you ask the person when they first call to determine if they have a cause of action?
Well, the first thing I do is tell someone, I understand you feel you've been treated unfairly, but the law doesn't recognize unfairness as a basis for bringing a lawsuit. So I need to know why you were treated unfairly. And what is it about the treatment that you think makes it illegal? Being unfair isn't illegal. You can fire somebody because you don't like the color of the shirt they're wearing, but you can't fire them because of the color of their skin. You can't fire them because they're older than 40. You can't fire them because they're of Mexican origin or some other country. We have to find out whether it's one of those boxes: race, religion, sex, national origin, color, age, veteran status, disability.
Or if you're a smoker in Kentucky.
In the state of Kentucky and several of the other southern states as well, the fact that you're a smoker. You can't fire somebody in Kentucky because he or she is a smoker if that person's willing to abide by your workplace smoking policy. The fact that maybe they cost you a little more in insurance premiums because they smoke when they're at home off duty isn't a reason to fire somebody in Kentucky.
Yeah. A few moments ago you indicated that you could fire someone for no reason or a good reason. I use the example that if your supervisor is a University of Kentucky fan and you happen to be a University of Louisville fan, your supervisor could fire you for being a U of L fan, because that's a bad reason and it's unfair, but it's not illegal. But as you point out, if you were denied a promotion because you were a female or because you're African American, in other words, if your employer was motivated by an improper factor, then you could have a cause of action.
That's right.
And once you determine that there may be an improper motive, what are ways that an employee can prove this before a court of law? Obviously, there's the overt discrimination if someone has said that they are prejudiced against females or African Americans or Mexicans, but if there's no direct evidence of discrimination, what are some ways that an employee can go about trying to prove that?
Well, those cases are harder, obviously. The "I don't want any women working here" scenario is easy to prove, and probably for that reason it doesn't happen too much anymore. Now we're in an atmosphere where you have to show it through indirect proof. So obviously support from your coworkers or former coworkers is important. If there are people who will give a statement or testify on your behalf that, yeah, she did the work just like everybody else, but they came down harder on her. They gave her worse performance evaluations or something like that. Another way I could imagine would be statistics. If, say, 99% of the workforce is male, well, that tends to indicate, it doesn't necessarily prove, but it's a piece of the puzzle indicating that workplace isn't exactly female friendly. So those sorts of indirect proof, anything, maybe I mentioned performance evaluations. If you could do a survey of the performance evaluations and determine that women always got lower performance evaluations than the men, but there's no real viable explanation for that. You could imagine scenarios where women might justifiably get a lower performance evaluation on some categories, maybe carrying heavy equipment, although there are certainly females who could carry just as heavy equipment as any man. But you might imagine that, if carrying heavy equipment were a category, a female might do worse in that category. But if across the board females are rated lower in every category on the performance evaluation, then that might tend to show that women are being held to a different standard than men.
If an employee has worked hard and done everything right, but is passed over for a promotion or perhaps is fired, I think one way to prove discrimination indirectly is to look how similarly situated people have been treated. What is involved in that kind of analysis? If you're trying to say, I was discharged for allegedly breaking a rule, but all the male employees who broke a similar rule have not been discharged, and therefore my sex must have been a factor. How does that work? And if you're looking for similarly situated people who were treated differently, how can that raise an inference of discrimination?
Well, similarly situated, it's what's called a term of art. It's one of those terms that courts use. Mm-hmm. And when they're evaluating a sex discrimination claim or one of these other discrimination claims, particularly for a failure to promote sort of scenario, they're going to look and see how people who are similarly situated were treated. And the focus is on the similar aspect of it. Somebody who was a 30-year employee probably isn't similarly situated to somebody who's worked there for 6 months. So we're going to talk about people who have basically the same tenure, or at least who are doing the same work. Somebody who's management or a low-level supervisor isn't similarly situated to somebody who's just a rank-and-file, low-level hourly employee.
Well, let's assume now that a person has come to your office and she says that she's a female, so that's a protected category, and she was discharged. That's a significant employment penalty to her, and she says that her employer gave the reason for her discharge was because she broke a rule, but she says the male employees who broke a similar rule, none of them were fired. So she has what we call a prima facie case, wouldn't she, at least initially, which means she has a right to present some information to the judge. How does an employer respond to this kind of case? What does an employer normally do to try and defend itself?
Generally, when employers try to defend those sorts of cases, they attack the similarly situated element by saying that, well, sure, these male employees were given multiple warnings for this conduct, but they weren't similarly situated to this employee because the particular rule that they broke was different than the rule that she broke. So they were given multiple warnings because, for example, they were absent on multiple occasions, or they came in a little late on multiple occasions. Well, that's a hardship, but it's not as significant as breaking a major safety rule that could have caused people to get killed.
So in other words, the employer tries to make a business justification for discharging this female plaintiff that we're talking about.
Right. The standard is always, did the employer have a legitimate non-discriminatory reason? The employer has the burden of offering some evidence to say that, well, we can't dispute that we fired her. Sure, that occurred, but we fired her not because she was over age 40 or not because she was a female. We fired her because we had this legitimate non-discriminatory reason. She did something that was so egregious that it justified termination, while what these other people, these men, had done didn't justify termination. And typically, it's going to depend on the facts, whether that sort of claim is going to survive the what's called summary judgment, where the employer says, hey, judge, we've proven that this was a legitimate reason, so dismiss the case. If the men are in fact similarly situated and they broke a rule and got multiple opportunities to continue working, then even if it was a less significant rule, if the company really bent over backwards for the men, then I'm a little skeptical that sort of defense is going to hold much water, at least in getting the case kicked out before it gets to a jury trial.
Okay. So in our example, The female has shown that she is a female, and that this could be an African American or a person over the age of 40 or someone who's disabled, that they have a characteristic that's protected by the law. They've had an adverse employment action, and they claim that other people in similar situations were treated differently. And now the employer has said, well, I have a business justification for firing you. It has nothing to do with your protected status. The plaintiff then has to do what? She has to try and disprove the employer's stated motivation. Is that right?
Right. And once the employer has offered that evidence of its legitimate business justification, then the employee has to respond to that purported legitimate reason by saying that, well, no, that wasn't that would be a legitimate reason if it were the real reason, but in fact that's not the real reason this happened. It's just an excuse to cover up their discrimination.
Mm-hmm.
And that's where things that we talked about a while ago, like having some support from your coworkers, or through the documents you get in the discovery process where the parties exchange information about each other, it's important to find some documents that show that, for example, the woman was doing a good job. Maybe the supervisor had written notes saying she's coming along just dandy, but then when performance review time came, she got low marks that are inconsistent with the notes, or however you could raise that sort of question as to whether the reason the company has offered really was the reason behind the termination.
Now, we focused on the lawsuit from the perspective of the plaintiff, but let's look at the perspective of the employer for a second. We've talked about the fact that in Kentucky, as in most states, we're an employment at law state, which means, or employment at will, which means that people can be fired for a good reason or no reason. That's unless they have a collective bargaining agreement in the form of a membership in a union or a written contract. But what steps should an employer do to try and protect itself when it's getting ready to discipline an employee?
Well, the first thing an employer should do, and I'm still amazed at how frequently employers haven't done this, but they should have an employee handbook, a book of their policies applicable to the workplace, and it should have a section in there that sets out the company's non-discrimination policy, which means the company should have a non-discrimination policy, saying that we don't discriminate on the basis of race, color, religion, national origin, sex, military status, smoking, age, all those things we talked about.
And of course that's required by law anyway.
It is required by law. And that non-discrimination policy should also say, we don't discriminate, but if you think you've been discriminated against, here's some people you can call. And it should list, a supervisor, and then somebody higher management. And if it's a really big company, then somebody in corporate human resources with an 800 number. So that way, if the employee is being, let's say, sexually harassed by her immediate supervisor, there's a way to go around that person to make a complaint. Because if the employee can get it resolved without ever feeling like she has to quit because she can't deal with it, or without getting fired, then that's in everybody's best interest. The employee never loses a paycheck, so the employee never comes to my office, so your client never gets sued, so your client doesn't have to pay you a bunch of money, so I don't collect a bunch of money from your client, so then everybody wins but us, and I think most people are happy when that happens.
I think people are not sorry that lawyers don't get their money. That's fine if they can resolve this amicably but among themselves. But it's important for employers to document anytime an employee engages in misconduct. Don't you think that's a good point?
Absolutely. Employers need to keep records of pretty much everything.
And as an employment lawyer that represents companies, I'm amazed that so many companies still do not document problems with an employee. And they get ready to fire someone for legitimate reasons, but they can't show a written documentation that the employee in the past has been late or has broken safety rules or things of this nature, because there's nothing in the record. And it makes it a lot harder for employers to defend cases if they haven't documented. Do you find that to be the case? Of course, you've represented both employers and employees.
I did used to represent primarily employers. Now I represent primarily employees, so I have seen both sides. And you're right, when the employee comes to court and gives sworn testimony in a deposition that, well, my boss said I'm not going to have any woman working here, and brings in some other employee, some coworker who maybe is no longer with the company, and gives a statement saying that, yeah, I heard boss man say no women are going to work at this place. Mm-hmm. And the company's going to respond, well, that never happened. She was doing a terrible job. And this guy who gave that statement, well, he's got an axe to grind because he was fired for X, Y, and Z misconduct, and he said, I'm going to get you on his way out the door. But none of that is reflected in the documentation. There's no documentation showing that the employee did a poor job. Well, what you've got now is unopposed testimony from the employee side of the case. The employer can scream till it's blue in the face that this isn't true, but if it has nothing to prove that, then we're left in just a shouting contest with between the employee and the company.
Right.
And at a minimum, that gets to a jury.
Mm-hmm.
And 50-50, a jury could come out either way, but the company spends a whole lot of money just to get to that jury stage and faces the possibility of losing at that point.
That's right, and it's difficult to criticize anybody, particularly a co-employee or one of your subordinates, but it's so important that if an employee is not doing what you expect him or her to do, that you counsel with the employee, that you document the counseling, that you tell the employee that they're not meeting expectations and standards, and you build a record so that, unfortunately, if an employee must be discharged or passed over for a promotion, then you as the employer have a record to show that it's not an improper motivation. It's not because the plaintiff is over 40 or a woman or an African American, but it's because of documented facts that shows the employee just didn't measure up. It makes a big difference, don't you think?
Absolutely.
And you mentioned a moment ago about sexual harassment. That's sort of a special part of employment law. Obviously, it's part of the motivation based on sex, that you can't discriminate against a person because of their sex. And we have had sexual harassment in the workplace, unfortunately, for many, many years. But could you tell our audience some of the new permutations of sexual harassment, that it's just not the older man against the young attractive secretary, female secretary, but what are some other types of sexual harassment that we're finding in the workplace?
I saw a story about this recently. I haven't seen any of these cases around here, but apparently a big, growth area, if you want to call it that, for sexual harassment involves teens, because teens are increasingly, more so than maybe 30 years ago, teens are an important part of the workforce now. A lot of teens have part-time, some have full-time jobs, and the types of environments in which they work, generally retail, food service, movie theaters, those sorts of places, have a lot of turnover and rely on management who maybe aren't as well trained as managers in a large corporation. So because of that, there's less clear lines as to what conduct is tolerated and what conduct is impermissible. And teens are still feeling their way around in the world. They don't really know what the rules are. So we run into situations where these teens are, particularly teen girls, of course, are subjected to lewd comments, to maybe some touching and what you might call horseplay that has some sexual connotation to it, and it might make these girls uncomfortable.
That's true. If I can tell a war story, I just concluded a case just like that. I defended a fast food operator, and it had younger male supervisors who were in their early 20s supervising teen women, and there was an accusation by two of the teen women that they were sexually harassed, improper touching, improper comments, And ironically, this store had video cameras throughout the store, and the females were able to get some of those tapes. And although, of course, I'm speaking from the management side, I don't think it showed egregious conduct, but it certainly showed inappropriate conduct, and that was a case that was settled. But that is a growth area, because you have younger, less experienced supervisors, particularly males, who haven't been instructed. And I think that's an important point about sexual harassment. It's vitally important for management to instruct the supervisors and co-workers about how wrong sexual harassment is. And it's not just the male against female. It could be a gay male against a straight male, or a female against a male subordinate. So sexual harassment has a variety of permutations, but it's vitally important that management instruct employees. And it's also important, as you pointed out, that management give employees information about how they report any inappropriate conduct. Because the law is written, as I understand it, that if management instructs its employees about the evils of harassment and gives employees an opportunity to report those violations, that can be a defense to an employment harassment case. But if employers don't give this kind of preventive work, they could be open to serious liability. Is that your understanding?
That's absolutely right. And it's a complete defense, which means if they've provided the information out there and the employee chose not to take advantage of the avenues made available to report or address the conduct, then the employee is just out of luck. She can bring the claim, of course, but the employer is just going to say, hey, here's our employee handbook, here's this sexual harassment policy, here's a list of people you could have called, and here's the piece of paper where you signed acknowledging that you had received the handbook. And if you chose not to use it, well, that's too bad. Mm-hmm. And the employer is going to win.
So the key is the employer can protect itself if it takes the initiative to educate and to police the workplace and try to be proactive. And it is the employee's obligation, if there is a policy in place, to follow that policy to try to bring some help and end to the situation. Is that correct?
Right. Like we intimated a while ago, if everybody's suing everybody, then nobody wins. The courts are already overloaded as it is, and people don't understand, I don't think, until they get in the middle of it, that litigation's a really horrible thing. It's time-consuming, it's stressful, it's emotional, and it's expensive. And it's better for things to just work, for employees to go to work, to do their jobs, to get their paychecks, to go home, take care of their families, and for employers to pay the paychecks, have employees who are doing their jobs and producing whatever product it is or delivering whatever service and having happy customers and making money. And
that's true.
It's just better for employer and employee to work together to get everything resolved.
I want to talk briefly about which court to sue in, because it deals with some timing issues, and then I'd like to talk for a few moments in the time remaining about disability discrimination. But just to make a point quickly, if a plaintiff wants to sue in federal court, they have to file a complaint with the EEOC within 300 days of the event. Is that correct?
That's correct.
That's in Kentucky. And then the EEOC will investigate the case and issue a right to sue letter, and that's your ticket to federal court. But in state court, how long does an employee have to wait before they have to sue in Kentucky State Court?
I believe it's
5 years, I think.
I believe that's right. I haven't looked that up recently, but I believe you're correct.
It is. I think it is 5 years. So if you want to go to federal court, you've got to file that EEOC complaint within 300 days. But if you want to go to state circuit court, you have 5 years from the adverse employment action to file your case in Kentucky state courts. Briefly about the Americans with Disabilities Act, I think a lot of people thought that the ADA would be a big boondoggle for plaintiffs' lawyers, much like a just a big disability claim, but we find that most courts now severely limit what is a disability for ADA. Is that correct?
Yeah, of course, it comes straight down from the Supreme Court, which has taken a very narrow view of what is a disability. A disability, to bring an ADA claim, Americans with Disabilities Act claim, one has to be a qualified individual with a disability. And what that means, or that's defined as someone who's substantially limited in a major life activity. And what we used to have, and some of these claims succeeded, including here in our own Sixth Circuit Federal Court of Appeals, claims saying that, well, I have trouble working, and work is a major life activity, therefore I'm disabled. And they won on that claim, even though the employer was pointing out, well, he's out playing golf. He's doing the shopping. He's a jogger. He's running down the street in front of this workplace where he can't work. And he's claiming he's disabled. And they won on some of those claims. And the Supreme Court said, no, that's pushing it a little bit too far.
So they have restricted it. And
they have restricted it.
If a person believes that he or she is qualified for relief under the Americans with Disabilities Act, it's important to see a lawyer early and to determine the extent of your disability, because, as you say, it has to be a very severe disability that it would affect, such as walking, seeing, hearing, or severely restrict your ability to work.
And one that I've seen come up recently that's a really case-by-case basis is asthma. Is asthma, does it meet the term, affect a major life activity? Well, if you have asthma and you get the occasional attack and you're kind of stunned for a minute or so and you take your inhaler and you're okay, that's not going to cut it under the ADA. The courts do now consider corrective devices like medicine and inhaler. So if the person can do that and be okay fairly quickly, get back to work, not a problem. But if the asthma is a major event that could result in imminent death, then we're probably talking about a disability for ADA purposes.
Well, to summarize, we've talked a lot about employment law, but really just scratched the surface. I wish we had more time. But I think the key things to remember for employees is that if you feel like you've been mistreated in the workplace, it's important to try to identify an improper motive by the employer as the real reason why you were discharged or passed over for a promotion or demoted. And that improper motive doesn't have to be the main motive, it has to just be one of the motivating factors. Is that your understanding?
That's correct.
And then if you feel like you have been unjustly treated, go to a lawyer and have him or her evaluate your case and do some studying. Frequently you can file a complaint with the EEOC and they'll do some free investigation for you. But then for the employers, document. Talk to your employees, keep communication open, and keep your records clear, and hopefully both you and the employee can avoid employment problems. But it's been a pleasure talking with you, Wes, and good luck.
Thank you. I've enjoyed it, Mark.
Thank you.